Yes, happy Constitution Day. It's September 14th. Normally Constitution Day is September 17th, but this year, September 17th falls on a Saturday, and we'll be busy destroying Florida State and not have time to worry about the Constitution. So we're doing it on the 14th, and I think this is an especially meaningful Constitution Day, being, of course, just so a few days after the September 11th solemn anniversary. The Constitution, more than anything else, I think, holds us together and brings us together as a country. And it's an important holiday that has become more important in the last few years at OU, thanks to the founding of the Institute for the American Constitutional Heritage. The IACH is now in its beginning its third year. It was founded 2 years ago by President Bowen to make OU a center for constitutional studies, to make the Constitution an emphasis of our undergraduate teaching, to make OU a nationally recognized center for research on constitutional history and constitutional law, and to bring programming to the university that makes constitutionalism part of a civil dialogue, part of a public engagement that really I think only a public university can bring. And it's been an exciting 2 years. We've made great headway. We've begun a concentration and a minor in constitutional studies, and OU is now one of the only colleges in the country, the only top-tier institution, where an undergraduate can concentrate his or her studies on the U.S. Constitution. I think that's a special mark for OU. We've created over 25 new courses, thanks to our faculty and affiliated faculty, and that number will only continue to grow. And we've brought exciting programming. If you were here in March, you saw our symposium on habeas corpus. If you were here last Constitution Day, you saw our forum, our panel on gun control. And it's a pleasure today to bring to you some of the participants in the front lines of one of the most important constitutional issues that's going on around us, and that's healthcare reform. I think this event today really symbolizes everything that the IACH can bring to campus, an enriching discussion on an issue that's really of fundamental importance for American citizens. And what we'll do today is we'll have first a talk by the Attorney General of the state of Oklahoma, Scott Pruitt. It's a privilege to have him here with us. And then he'll take a few questions and answers. But let me say how this is going to work. Megan, where are you, Megan? Megan, who's my wonderful program specialist, has been handing out index cards at the front of the room. If you didn't get one and want one, you can raise your hand and she'll bring you an index card. If you have a question, please write it on the index card. And in about 10 minutes or so, we'll come around the room kind of asking you to pass down the cards. So if you have a question, write it on there. You can write your first name if you want. You can write your last name if you want. You don't have to. And then we'll collate those and try and ask the questions that get to the issue and that aren't repeating each other. So please write down your questions soon in the first few minutes if you can, and we'll be collecting those. Then the Attorney General has graciously offered to answer a few questions, and after that we'll have a panel discussion featuring our three panelists. We have with us for the panel two internal experts here from OU, Professor Rick Tepker at the law school. Rick, will you wave to the crowd here? Teaches constitutional law at the law school. We have Justin Work from the political science department, and we have Patrick Wyrick, who's an OU graduate and an OU law graduate, and is now acting as the Solicitor General in the Office of the Attorney General. So thank you very much, Patrick, for being here. It's truly an honor to have with us the Attorney General of the state of Oklahoma, Scott Pruitt. Mr. Pruitt grew up in Lexington, Kentucky, where he was an all-star baseball player. In fact, got a college scholarship. Ended up getting a bachelor's degree in political science at Georgetown College before going to the University of Tulsa College of Law, working his way through law school and earning his JD with distinction. He then went into private practice for several years, practicing constitutional and employment law. Before he was elected Attorney General, he served as Broken Arrow, Coweta, and Tulsa as representative in the Oklahoma State Senate for 8 years, including Republican floor leader for 4 years. With his leadership, the state legislature passed the Religious Freedom Act, and as you know, if you've been coming to IACH events, religious freedom is one of our focal issues this year. He made Oklahoma one of the first states to pass an act that makes it more difficult for a government to burden an individual's practice of faith. Oklahoma Attorney General Scott Pruitt was elected to the office of Attorney General in November 2011. And since coming into office, he's independently filed suit questioning the constitutionality of the Federal Health Care Act. And for the first time in our country's history, he's joined 27 other state attorneys general to challenge the federal government's actions. It's truly, I think, a privilege for our students and faculty and community to have him here with us today. And we're so grateful that he's here. Please join me in giving him a very warm welcome.
It's an honor to be on campus with you all today, and I'll tell you, I really appreciate his reference to the fact that I was an all-star baseball player. I didn't know that, but I appreciate the reference. And sometimes when I'm introduced, in fact, I just got back from Kentucky. I was there campaigning on behalf of colleague and a friend, and sometimes when I'm introduced, they say that I played basketball at the University of Kentucky, and then I stand up from behind the podium and they say, you didn't play basketball at the University of Kentucky. And that's true, I played baseball there. But it is an honor and a privilege to be here with you today. I'm really excited about what's going on campus with this Constitutional Studies program. Kyle has spent some time educating me in my office about what you're doing, and it is exciting to see. To allow an undergraduate the ability to get an emphasis in constitutional studies in a letters program, to understand the implications of our structures of government in a way that's in depth, whether it's business or finance or it's a very exciting thing. And to see OU leading the way, it's rewarding. So Kyle, I want to say thank you to you for your leadership, and glad to see you back in Oklahoma leading this effort. How many students do we have here in the program that's with us today? That's good. And understand that the jackets with the what is that on your jacket? A little crest of the Capitol or something. That's the Fellows program that you were talking about, Kyle. Anyway, it's exciting to see you, and I appreciate the opportunity to be here. You know, when we talk about the Constitution, I really appreciate Kyle sharing with you my background in constitutional law. My focus when I was in practice was in the Section 1983 area, particularly the First Amendment. Defended companies and engaged in other constitutional lawsuits in that regard, and really thoroughly enjoyed it. It's what really spurred me, my love of the Constitution and the love of U.S. history, spurred me to go to law school. And when you look at what the founders did at the beginning, it just is real exciting. In fact, I've often compared it to what business leaders do today. You know, today we have business leaders that gather together around a table, they've got ideas, and they say, let's risk for the sake of an idea. And when the founders gathered together many, many years ago, they really had nothing more than an idea. I mean, it was an abstract concept. It was real in the sense of what they were putting on the line, but it was an abstract concept. They really took a risk to say, we believe enough in this idea to form this country and to declare our independence and begin this Revolutionary War, and culminated, obviously, with the Constitution. The Constitution in and of itself, a very unique thing, a written Constitution. It was against the clear weight of history at the time, and I think that's just exciting that we come from that. And when you look at what we're battling today, this healthcare lawsuit, I'm glad we're talking about it because it's emblematic of other issues that my office faces. As Kyle mentioned, Patrick Wyrick is my Solicitor General, and before my administration, Oklahoma didn't have a Solicitor General. 38 other states did. And if you know what a solicitor does, a solicitor spends his time or her time in appellate advocacy before the 10th Circuit, before our state appellate courts, the U.S. Supreme Court and our state Supreme Court. That's where Patrick spends his time. And he spends time giving meaning to the Constitution. And I thought that was important for the state of Oklahoma to have a real voice in the courtroom each and every day dedicated to the principles we're going to talk about today. Because when you talk about federalism, and you talk about these issues that we're confronted with as a country, federalism really is vertical checks and balances. You know, we know about judicial, executive, and legislative and horizontal checks and balances, but federalism really is equivalent of vertical checks and balances. There are certain powers that have been given and specified to the U.S. government, the federal government, and then powers that are reserved to states and to individuals. And the founders did that for a reason. They were astute enough and wise enough to know that a federal government doesn't need and shouldn't have plenary power. It shouldn't have police power, which is what the state has. It should have very specific enumerated powers because it is the government that operates the farthest from us as individual citizens. And as the government that operates the farthest from us, they should have very specific powers because otherwise liberty and freedom may be affected. And so the first thing that I want to say to you about this federal health care law is, number one, you'll never hear me say Obamacare in reference to our challenge as a state. And here's why. That makes this challenge partisan. My good friend Ken Cuccinelli, who's the Attorney General in Virginia, filed his lawsuit in March of 2010. The ink was drying on the federal health care law at that time. The major criticism of Ken Cuccinelli at that time was not that his argument lacked merit or that he didn't make a salient argument about the unconstitutional aspects of the law. It was he was doing it for political purposes and political purposes only. And Ken Cuccinelli, to his credit at that time, said, no, that's not the case, and I will not refer to it as Obamacare because this is about the Constitution. And we have heeded his advice, and that's what I've shared with my team, with Patrick and others, that this is about the Constitution, not about partisanship. And I'll say this to you. It's not about health care. I was in the Senate for 8 years. State Senate. And I believe that health reform, health policy reform, health care reform is an area of desperate need as far as state and federal solutions. We need policy initiatives as it relates to health care. I owned a business for 8 years. My medical inflation as a business owner was 10 to 15% a year. It's beyond that today. Ask most business owners. Your cost as an individual citizen is skyrocketing. So policy initiatives on how to address health care are extremely important. Our only concern as an office is that it's done consistent with the Constitution. That the role that the federal government plays and that the role that the state plays work together in adopting policies that are consistent with both our U.S. and state constitution. So within 2 weeks after having been sworn in on January 10th of this year, we filed our lawsuit in the Eastern District of Oklahoma. January 21st, we became the 28th state, and as Kyle mentioned, never before have 28 states joined together in a lawsuit as party plaintiffs against the U.S. government. Many times a state will file an amicus brief, file an opinion with the U.S. Supreme Court or otherwise and say, here's what we think you ought to consider. But for 28 states to join together as party plaintiffs to say that the action taken by the U.S. government was unconstitutional is unprecedented. We became that 28th state, and when I took office, I really had two decisions. Should we join Florida in their proceeding? At that time, they had 25 of the states, 26 total, that had been filed in Florida, or file separately, file individually. Because I believe that the issue of import, whether the federal government had the ability under the Commerce Clause, the authority under the Commerce Clause to require each person in this room to buy health insurance, was a constitutional issue that we needed to address as a state. Campaigned on that. I believe that today because the precedent that this sets is substantial. And I'll talk about that in a second, and I'm sure Patrick and the panel will as well. So the first question was not whether we fought. The question was how we were going to engage in the battle. And the two choices were to join Florida or to file separately. Now, as you know, in November of last year, the state of Oklahoma passed a state question. And Oklahoma said that no government, including the state, by the way, and that's an important point that I'll make in a second, but that we passed a state question that said no government could compel an individual to buy health insurance. And so when I made the decision to file in the Eastern District of Oklahoma, in Muskogee, I believed it was more appropriate to defend our Constitution before an Oklahoma judge as opposed to a Florida judge. And that's what drove our decision. Now, with respect to this issue about states, I've heard some of the presidential candidates ask this question. Do the states have the power to compel individuals to buy health insurance? And I've heard some of them very smart folks, and some of them attorneys, have said, no, the states don't possess that power. I disagree. I believe the state of Oklahoma could next session in the legislature require everyone in this room to buy health insurance. But for a different reason than why I believe the federal government doesn't have that power. As I started my conversation, I talked about federalism and vertical checks and balances and specific and enumerated and limited powers being given to the federal government. If you go and listen to the arguments, it's very interesting. Patrick and I have done this. If you haven't done this, I highly recommend that you do it. Go listen to the oral arguments. You can get it online. You can get it taped in the 11th Circuit, the 6th Circuit, the 4th Circuit. Go listen to the justices asking the U.S. Solicitor General this question. The U.S. Solicitor General has been asked, if this power is available to the U.S. government under the Commerce Clause to require every American to buy health insurance, where are the boundaries? What are the limitations? In fact, they followed up by saying, in effect, isn't that a general police power that's being given to the U.S. government if they're given that power under the Commerce Clause? And you know what the U.S. government has said in response? They've had great difficulty answering the question. The response has been, well, healthcare is just unique, and we should treat it differently. That's been their response. I've got, if you want to read that, I think Patrick's got this as well. I don't have the entire opinion. If you go pull the 11th Circuit opinion, it's about 307 pages, right, Patrick? This is just several excerpts of the 11th Circuit opinion. I highly recommend that you look at it, because the 11th Circuit makes the point, well, if these exigent circumstances, if healthcare is unique, then why did the U.S. government during World War II come out and require people buy bonds, war bonds? That seems to be a pretty substantial need as a country. Why didn't they use some type of commerce power to come out and require individuals to buy war bonds? Great question. And that's what the 11th Circuit struggled with, was the boundaries and the limitations and the fact that if the federal government has this power under the Commerce Clause, it is the equivalent of the general police power, which does what? It trumps our protections with respect to federalism.
If you would say a little more about the Commerce Clause specifically and how you think the merits of the case will be ultimately decided. How is this going to look?
Well, first, I think the federal government has the authority and power to do what they did as far as compelling us to buy health insurance, but they used the wrong provision of the Constitution. A lot of folks say, wait, this is just like Medicare. No, it's not. Here's why. Medicare, Social Security is a tax. And the U.S. government had the authority to come into this debate and say, we're going to tax the American people in this way to compel the purchase of health insurance. They could have done that. They expressly did not. You know why? They couldn't pass the bill. That's why they didn't do it. In fact, if you go look at the legislative history, you look at around what was going on in Congress at that time. So when you look at the Commerce Clause, Kyle, and you compare it to other powers the federal government has, I believe the federal government has the power, but they use the wrong provision, and that matters. Because the jurisprudence and the precedent that's set by using the Commerce Clause in this way begs the question, where are the boundaries? And you know why the boundaries matter? Because in a nation where rule of law governs us, businesses and individuals need to have the ability to do what? Predict their conduct. They need to be able to look out and say, this is the expectation placed upon me. If I engage in this conduct, I can anticipate because I see a precedent. I see boundaries. I see limitations. I see something definite that I can govern my conduct by. When you say to the U.S. government in an ad hoc fashion, you can come in and say, you know what, this is an exigent circumstance. And consequently, we need to be able to use the Commerce Clause to come in and legislate in a way that does not give predictability in advance to individuals. That's why this is unconstitutional. It's not to say they couldn't have taken another approach. They chose not to because they couldn't pass the legislation for the taxing power.
Okay, we've got a lot of really good questions here. We'll get to a few of them. One that appears multiple times in this is, why can a state require, say, collision auto insurance prior to getting an automobile tag, but not private health insurance?
It's a great question.
Can we hear somebody else respond, please?
Great question. And the answer to that is, in fact, I'll say two things. Number one, does the state of Oklahoma require you to buy auto insurance if you don't own a car? No, they don't. And the state of Oklahoma uses police power, plenary power, to mandate the purchase of auto insurance. That's what the lawsuit's about. The federal government doesn't have the same kind of power that the state of Oklahoma has. They have specific enumerated powers, and if you give them the power to do what they did under the Commerce Clause, you've effectively gutted the plenary and police power that states have. That's why the states can do it. That's why the states can require everyone in this room, but for our state question we passed in November of last year, to buy health insurance. Massachusetts did it. Maine did something similar to what Massachusetts did. The state of Oklahoma, the state of Texas, the Commonwealth of Virginia. But for legislative action, statutory or constitutional, could require each of the respective citizens to buy health care, to deal with the policy aspects of health care. That's something the state possesses, the federal government doesn't.
Someone asks, why is it legal to require all hospital emergency rooms to receive and treat all persons, which is the most expensive form of health care, but unconstitutional to require persons to have private insurance to help pay for the expenses of health care?
That's purely statutory. That was not always the case and not always the law. The U.S. government I think in the early 90s, passed the statutory requirement that hospitals can't turn away individuals at the emergency room. So that's purely statutory, it's not constitutionally driven. The federal government could change that tomorrow.
Good. Is either a state government or federal government's job to provide for the welfare of the people, and should access to health care, either on a state or federal level, be a constitutional right?
No, it shouldn't be a constitutional right.
Okay, a couple more questions. Is the use of the promote the general welfare phrase in the preamble of the Constitution, a defense of the individual mandate, a valid?
Well, if it is, the federal government has not made the claim, and they've been looking for several. In fact, they started off with very ambitious and aggressive argument on the Commerce Clause, and if it's very, I highly recommend go listen to the 11th Circuit, 6th, 4th, the arguments that are made by the U.S. government in response to the Justice's question. You see a trend, and I think Patrick will address this. They start trending toward the necessary and proper clause. It's giving them more of a general right to do what they did as opposed to the Commerce Clause, because I think of the problems that they were seeing with the Commerce Clause. So I've not seen the argument with the general welfare. These gentlemen may have. I've not heard it in the argument. It's been more of a Commerce Clause / necessary and proper analysis.
Okay, one last question, then I want to let the panelists speak, if that's okay.
I think this gentleman will like that.
What is the, I don't know what that gentleman will like. What is the substantive difference between a tax that gives an individual the right to a service and a legislative obligation to purchase a service or else suffer the imposition of a tax? This is a good question. In both of these scenarios, the end result is a tax, which is within the bounds of the Constitution. But even if it's unconstitutional, why should the ambiguous dictates of the Constitution be prioritized over a healthcare plan that has been demonstrated to be more effective around the world? What is the utility of a Constitution that precludes good policies? I know I wrote this one.
Objection compound. But I think the genesis of the question is really what authority, what power does the federal government choose in enacting legislation? Unlike Oklahoma, go try to find legislative history in Oklahoma. Go try to find it. You can't. They don't even record the committee votes. They may have changed that this past session, but they don't have legislative history. The U.S. government does, and it's substantial. And it matters to courts. We sometimes criticize the courts of being activist. You know why they're activists at times? Because the legislature doesn't do the job at filling in the blanks on why they're taking certain action. That's why they're activists. We don't have to guess, Kyle, what the U.S. government was doing with this legislation. They were addressing the policy concerns of rising medical costs. The uninsured population had added 16 million people to the insurance rolls, and they felt the most effective way to fund the policy changes, taking away pre-existing conditions and the rest. The most effective debate, the discussion, betters America, and I'm thankful to be in a state and a country where we can do that in a civil way. So thanks very much, and I appreciate the opportunity.
Thank you very much. Now we're going to have three panelists, no audience members.
No audience?
No audience members. No, you can sit down.
Okay.
And now we'll have the three panelists, just like we planned. First, Professor Tepker, then Professor Wirt, and then Solicitor General Wyrick, each giving a statement and then opening up to general discussion between themselves.
Today we discuss the oldest constitutional controversy, the powers of a national government and the role of the states. Madison, Hamilton, Washington, and their allies met in Philadelphia to frame the Constitution, that exciting moment that the Attorney General referred to. They created a national government, a government worthy of we the people, and a government capable of governing the nation. 150 years ago, this year, the nation tore itself apart after some politicians, primarily in the South, showed an exasperating disregard for the plainest facts and pretended the Constitution barred Congress from regulating slavery in Western territories. They persuaded the Supreme Court to render a disgracefully reasoned opinion in the Dred Scott case, rooted in mythic notions of state sovereignty and the primacy of state police powers. The end result was rebellion that nearly destroyed the last best hope of Earth, a rebellion that had to be quelled by a determined national president. 75 years ago, preachers of an old-time constitutional mythology denied that Congress had capability to address the Great Depression. and a determined nationalist president had to fight the battle with the court, with the Liberty League, with others, to preserve Western civilization from a totalitarian fate. Half a century ago, the same constitutional myth stood in the way of a determined nationalist president who knew it to be past time, long past time, to address civil rights with federal remedies. Again and again, the court confronted these aspects of the nation's oldest constitutional controversy, and again, with some exceptions, the court said the issue was a relatively straightforward problem. Can Congress choose its own public policy to address problems it deems to be national in character? The court said again and again, yes, and on those few occasions when it said no, it overruled itself, sometimes quite quickly, sometimes after a period of time. The court understood that to inquire into the wisdom of congressional legislation is to go beyond the judicial role and to tread on legislative ground. We call that judicial activism. And you must understand that's what Oklahoma is asking the federal courts to do, to engage in the most blatant form of judicial activism. Now, once again, we are engaged in a great constitutional debate. The professional legal arguments, which you've heard in briefs and heard here today, are eclipsed by political rhetoric, such as the rhetoric surrounding State Question 756, including loose talk of state sovereignty, secession, nullification, which is at the heart of 756, and states' rights. How strange a time it is that such rhetoric is called conservative, an honorable adjective for an honorable tradition that has been at its best skeptical, realistic, facts-based, and science-respectful. Today's rhetoric is, of course, right-wing, but populist. It does not stabilize, it does not preserve, it does not cherish, it does not respect our traditions and our constitutional heritage. There are only 3 points we need to make in order to get to the heart of the matter. First, there is not a syllable in the Constitution suggesting that the individual citizen has a right, a general right, to be let alone when deciding to trust to the generosity of neighbors or state taxpayers or federal taxpayers to cover the risk of sickness, disease, or accident. Rising emergency medical costs are passed on to all of us, and particularly employers and businesses, by taxes or insurance premiums. It is a substantial, real problem of national consequence, precisely the kind of interstate commercial consequences we, the people, wanted our Congress to have power to address. Second, despite what you heard here today, Congress has been taxing and spending and regulating about health care and health insurance markets for half a century. There is no meaning to the claim, no basis for the claim that health care or health care insurance is some separate categorical subject separated from national power. The country's history over the past half century is all against it. Finally, health care presents a question of public policy. It is a conflict over whether regulation of the healthcare industry is wise. Should the law ban discrimination by insurers against those with pre-existing conditions? Should the system be constructed to spread risk across the entire population? Should healthcare in this country be constructed as a profit-based gamble in which the well-financed make bets for and against the safety and health of human beings? Should healthcare in America be focused on a protection of actuarially preferable patients? These are policy questions, not constitutional questions. And over again, the court has addressed such questions of economic regulation and reminded voters the wisdom of a public policy is not a matter for judges. It is for the representatives of we the people. These conclusions rest squarely on the public views of Washington and Madison, John Marshall and Thurgood Marshall, Abraham Lincoln, Justices Holmes and Brandeis, the Presidents Roosevelt, and even Justice Antonin Scalia. It is a tragedy that so many states in this day and age have attempted to resurrect the antiquated, discredited, discarded doctrines of those who, like John C. Calhoun and Jefferson Davis, denied and defied the nation's nationhood. Today's a day for celebrating and remembering the Constitution. In all the years past, no one has improved on what our greatest Chief Justice, John Marshall, said about our supreme law. Our Constitution was intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs. That endurance and that adaptation requires respecting the importance of politics, the choices of the people's representatives, and the democratic traditions of our nation. The court must keep its promises of self-restraint and leave these issues to the Congress and the President of the United States. Thank you all very much.
I want to thank Kyle Harper and his program specialist, Megan Denny, very quickly for putting together yet again another wonderful Constitution Day event. These are really exciting, and I'm always honored to participate in them. In his classic work, Democracy in America, Alexis de Tocqueville remarked that, quote, scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. Tocqueville's observation remains just as true today as it was in the 1830s, especially with respect to health care reform. Since President Obama assumed office, no other issue has divided our country politically as much as the passage of the Patient Protection and Affordable Care Act. Just to give you a sense of the political divisiveness of the issue, consider the following. Not a single Republican voted for the bill in Congress. Since the bill's passage, the Republican-controlled House of Representatives has even voted to repeal the bill, not unsurprisingly. The days and months leading up to the passage of the bill in 2008 led in part to the formation of the Tea Party movement. And in no small way, this movement and their characterization of the health care bill as Obamacare helped Republicans win back the House of Representatives in 2010. Most state attorney generals who are challenging the constitutionality of the bill are Republicans, and most attorneys general who have filed briefs in support of the constitutionality of the bill are Democrats. When we look at the federal judges on the district and circuit court levels that have heard challenges to the bill so far, we see that almost all of the justices who have ruled that the bill's most important provision, the individual mandate, is unconstitutional, were not unsurprisingly appointed by Republican presidents. And almost every justice that has voted to uphold the constitutionality of the bill, and the individual mandate in particular, were appointed by Democratic presidents. And finally, some Republicans and Republican or conservative or libertarian-leaning think tanks have even switched their positions on the most controversial part of the bill, the individual mandate. The Heritage Foundation, for example, a conservative think tank, supported the individual mandate as an alternative to President Clinton's health care reform bill in the early 1990s. And of course, now presidential candidate Mitt Romney, and former governor of Massachusetts, supported and signed into law a nearly identical bill in that state, which so far has proved very successful in reducing healthcare costs across the board in Massachusetts. As a political scientist, which I am, who studies and specializes and writes and researches about constitutional law, I find these political issues of the healthcare reform debate more instructive in many ways than the purely legal arguments about the bill's constitutionality. And I find them more interesting and instructive from a political perspective for two reasons, which I'll talk about. The first is that I think the bill is clearly constitutional. So that's answered in my mind, but I'm sure we'll talk more about, and maybe I'll have the chance to tell you why I do think it's clearly constitutional in our roundtable discussion in a few moments. I will say, though, and this is an important point to make, that just because I believe that a piece of legislation is constitutional, that does not mean that I think a piece of legislation is wise. And there is a very, very big difference there. The second reason that I find the political aspects of the debate more instructive is that they can help us understand how politics actually works in practice in the United States. One thing political science research can teach us, it can teach us more than this, I can convince you of that at another time hopefully, is that political parties often use the courts to get their work done. When a party, like the Republicans in early 2008, were in the minority or are in the minority, They obviously have a difficult time voting down bills with which they disagree. One way to overcome this institutional reality then, and we've seen this phenomenon played out many times in American history, is to appeal to courts, especially when the court is tilted in your party's favor. And the reality is that this is a very reliably conservative court now, made up of a majority of justices appointed by Republican presidents. And that, I believe, is what the constitutional challenges to the bill really are. Political end-arounds by the Republican Party. And this is not a criticism of the Republican Party in their efforts to do this end-around. I'm not trying to be derisive as I use that term. Political parties do this all the time. And it's a feature of America, of the American political system, that we should pay attention to and recognize when we see it. Again, I'm not criticizing them for doing it, but as a social scientist, I see that, and my fellow colleagues see that as well. Again, it's not criticism. So in other words, unable to kill the bill in Congress, the Republican Party more generally is hoping that an appeal to a conservative court will get them what they could not get in the political arena in 2008. Whether the Republicans will be successful in their challenge, though, is another story, and I'm definitely sure we'll talk about that in our roundtable discussion in a few moments. But what is interesting politically is that since the Republican Party has taken back the House, and especially if they're able to maintain control in the next election cycle, it has been the case that President Obama and other Democratic leaders have talked about scaling back some of the bill's provisions. Not the individual mandate, but some other provisions. An olive branch, so to speak, to the Republicans to bargain, which they have not responded to my knowledge. But this, I believe, would be the most fruitful way to resolve the controversial issue of health care reform in the political, not the legal arena. A decision by the Supreme Court oftentimes, and I think in this case might be the case, runs the risk of not having as much legitimacy as would a decision by a Congress, by a bipartisan Congress that could resolve this issue. So while Tocqueville's observation might still be true then, that scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question, that does not mean, nor do I think that Tocqueville intended it to mean, that it is always wise to turn political issues into legal ones, which we have done with health care. Thank you and happy Constitution.